Hello, everybody. Hello. Welcome. Couldn't leave this week without going through this really interesting motion and order that has just come out from the DC court. So I wanted to make sure to actually read through the document, and then I will do a Q&A after I'm done reading. But I did want to set this up so that I'd be able to actually get through the document before the comments came in. So if everyone would be so kind as to hold on for just a few minutes while I read through the documents, and then I will be coming in and doing a Q&A to follow right afterwards. So let me make sure I'm in frame. Should be, according to everything I've got, I am. So hopefully we can stay in frame. So here's what we've got. Let me just mark this off. This is kind of last minute, just came down. So we have Judge Chutkan out of the DC Federal Court. She has issued an order regarding an opinion regarding a specific situation that had been going on there in court. So I'll take you through that order, and then I will take you through the unsealed motion that the government has filed regarding what's going on in the case. So I will just dive right in, everybody. It looks to me like everything's in frame. That's one thing about having the comments off, is I can't tell. So I'm hoping everything's okay. Let's just dive right in then. Again, this is the order for the DC case. Let's dive in. After this, I will go through the government's motion. So, opinion and order set out here. Let me make sure I'm in frame properly. The government has requested leave to file a motion under partial seal, specifically to file an unredacted version of that motion under seal, and to file a redacted version on the public docket. As set forth below, the government has carried its burden to justifying the limited redactions it proposes, and the court will grant its request. The D.C. Circuit has recognized the important presumption in favor of public access to all facets in criminal court proceedings. In assessing a request to file a submission under seal, the court must weigh 6 factors to determine whether the presumption's outweighed by the need to seal the materials at issue. So she's making a decision. Should we unseal it, or should we keep it sealed? Here are the factors. The need for public access to the documents at issue. 2, the extent of previous public access to the documents. 3, the fact that someone has objected to disclosure and the identity of that person. 4, the strength of any property and privacy interests asserted. 5, the possibility of prejudice to those opposing disclosure. And 6, the purposes for which the documents were introduced during the judicial proceedings. This is the test to see if we're going to unseal it. As the moving party here, the government must come forward with specific reasons why the record or any part thereof should remain under seal. Relatedly, when certain kinds of documents in a criminal case have historically been open to the press and general public, and public access plays a significant positive role in their function, those documents may implicate a qualified First Amendment right to public access. That's the key. We've got the First Amendment coming in here. If the government seeks to seal such documents, it likewise must demonstrate that 1, closure serves a compelling interest, 2, there is a substantial probability that in the absence of closure, this compelling interest would be harmed. And 3, there are no alternatives to closure that would adequately protect the compelling interest. Here, the government seeks leave to file a substantive motion and asks to redact from that motion, 1, the names and other identifying information of certain individuals whom it asserts defendant targeted with inflammatory public statements and who were subsequently subjected to threats and harassment. And 2, excerpts from witness interview transcripts describing the threats and harassment they received. The latter category of redactions is from materials designated as sensitive by the protective order entered in this case. By the mere fact that material may be subject to a protective order limiting disclosure does not mean that it must remain shielded from public disclosure. Now, flipping here, again, hoping I'm in frame for everyone. To approve the sealing of any materials in a criminal case, the court must still engage in the analysis required by the common law, Hubbard factors, which she just went through, and where applicable, the First Amendment. So the Hubbard factors. On balance, the Hubbard factors support the government's proposed redactions. First, the need for the public access to the redacted information is relatively small. The court acknowledges the intense public interest in and attention to this case and has affirmed its commitment for this case to proceed in the public record as much as possible. But Hubbard instructs that even when there is generalized public interest in a matter, the purposes of the public access are only modestly served by unsealing information that is not material to the relevant judicial decision. In its motion, the government seeks to establish that defendant has publicly criticized his perceived adversaries and is aware that this criticism has led to their harassment. That proposition does not turn on either the identities of the specific individuals whom the government cites as examples or the broader transcript excerpts of witness interviews that the government's motion summarizes without redaction. Accordingly, the redactions will not significantly affect the public's ability to understand the basis for the motion or the court's eventual decision on it, which reduces the weight of this factor. The second Hubbard factor, the extent of previous public access, applies differently to 2 distinct categories of proposed redactions. The public has had no access to the witness interview transcripts. By contrast, at least some of the names, titles, and other redacted identifying information have been included in, among other public sources, media reports about defendants' public statements and their aftermath. The defense argues that with respect to those redactions, an internet search for the quotes or other unredacted information associated with each example in the government's motion could reveal the individual's identity, such that the broad substance of the redactions is already public knowledge. But even assuming that is true, it does not necessarily compel the parties or the court to disclose the specific details of that identifying information. The need or to conduct independent searches or make inferences to confirm the redacted identities undermines the assertion that they are already public. In short, the public's previous access to the redacted information has been limited for the individual identities, to none for witness interview transcripts. Under the third Hubbard factor, the court considers who, if anyone, objects to the disclosure. In this case, the government objects. The fact that a party moves to seal the record weighs in favor of the party's motion. But the government has a unique interest in protecting the integrity of its investigations, and it would be difficult for another third party, such as a witness whose name is redacted here, to object without revealing their identity, which is precisely the information the government seeks to protect. In that sense, then, the government's objection is aimed at protecting third parties' interests. So, the need for minimizing intrusion is especially great, and adds further weight in favor of redaction under this factor. Fourth, the court turns to the strength of the privacy interests at stake. Those interests extend to witnesses and informants who provide information during the course of an investigation. Now we'll bump over to page 5. The court has already noted its concern that members of the public who are not bound by defendants' release conditions might use sensitive witness information in ways that intimidate witnesses or otherwise threaten the integrity of the proceeding. The individuals whose identifying information and transcripts are redacted have already been harassed and threatened, and they have a strong interest in not repeating those experiences. The risk of that happening weighs substantially in favor of permitting the government's proposed redactions. The fifth Hubbard factor evaluates the possibility of prejudice to the party opposing disclosure. The government has identified a significant risk to its interests. Witness intimidation could not only affect the willingness of any of the targeted individuals to participate in the law enforcement process, but also could chill the testimony of other potential witnesses in this case. Courts in this district have repeatedly recognized the need to protect witness anonymity, including because of compelling law enforcement issues in maintaining the ability to obtain truthful information from subjects or witnesses who can trust their statements would in fact be kept private. And the Supreme Court has emphasized that preserving the anonymity of witnesses encourages them to communicate their knowledge and therefore supports effective law enforcement. This factor weighs in favor of the redaction as well. Sixth, and finally, the court examines the purposes for which the government seeks to use the redacted information. The analysis under the factor parallels that of the first. As already explained, the identifying information of the individuals targeted by defendants' public statements, along with portions of their witness interview transcripts, are not material to the government's assertion that the defendant will continue to make similar personal attacks, knowing that they may prompt similar harassment. Those specific identities and their accompanying transcripts will have minimal effect on the court's decision whether to grant the relief the government solicits in its motion. Consequently, the sixth factor also supports granting leave for the government to make its requested redactions. In sum, there is little need to publicly identify the specific individuals whose information and witness transcript interviews the government proposes to redact. All told, the redactions concern only the identities of a few examples in a single subpart of the motion's background section. The motion does not rely on the redacted information, and that information is not essential to the court's decision. On the other side of the scale, the individuals behind those redactions have already experienced harassment and threats due to the publication of their information, and the possibility of that happening again risks witness intimidation, including of other witnesses not identified in the motion. While it may be possible for some observers to infer certain redacted identities based on publicly available sources, that alone is not sufficient reason to require the disclosure of the redacted information here. The court therefore concludes that the Hubbard factors support a partial seal of the government's motion limited to its proposed redactions. Let's talk about the First Amendment. The defendant contends that there's a First Amendment right of public access to the redacted information, but that right only attaches to materials in criminal cases for which, 1, there's an unbroken, uncontradicted history of openness, and 2, public access plays a significant positive role in functioning of the material. And that takes us to page 7. For example, the Supreme Court has recognized that right of access to criminal trials, voir dire proceedings, and preliminary hearings, and the D.C. Circuit has recognized it for completed plea agreements, but not unconsummated plea agreements. The defense has not pointed to any history, much less an unbroken, uncontradicted history, of motions like the government's being fully available to the public, nor has it articulated why public access significantly contributes to their function. There is little indication of a First Amendment right of access in this instance. To begin, the court is unaware of any specific precedent or history for that right in the context of a motion seeking to restrict extrajudicial pretrial statements or to require notification before conducting a survey of the potential jury pool, much less the identifying information of potential witnesses embedded in those motions. Indeed, the Supreme Court has squarely held that the restraints placed on discovered but not yet admitted information are not a restriction on a traditionally public source of information. Identifying information in a motion dealing with the pretrial collection and public dissemination of information seems closer to mere discovery to which the public has no right than it does to evidence attached to the dispositive beliefs or submitted in open court. In addition, public access to the proposed redactions is unlikely to meaningfully contribute to the function of the government's motion. As a general matter, public access can strengthen public confidence in the outcome reached by the court. But as explained above, the information the government proposes to redact is not essential to the motion's claim and is therefore not necessary for the public to independently evaluate the parties' arguments and the court's conclusion. Ultimately, however, the court need not decide whether the First Amendment applies here, because even if it did, the government has met its burden to justify the redactions. Preventing the witness intimidation is a compelling interest for the individuals whose information has been redacted. For the government's law enforcement purposes and for the public interest in due administration of justice in this case. And we've got precedent here. The history of harassment and threats towards the individuals whose information has been redacted demonstrates the real likelihood that they could suffer further intimidation upon disclosure of their identities, and the government's proposed redactions are tailored to mitigate that risk, covering only those individuals identifying information in a handful of instances and the witness interview transcripts. The vast majority of the government's motion, including all of its key evidence and arguments, remains fully available to the public. Any First Amendment right of the public access to the motion would therefore be satisfied, notwithstanding the government's limited redactions. In conclusion, for those reasons, the government's request for leave to file unredacted motion under seal and to file redacted motion on public's docket is hereby granted. The clerk of the court is directed to file under seal the unredacted copy of the government's motion, attaching Exhibits 1 to the motion under seal as well. The clerk of court is further directed to file on the public docket the redacted copy of the government's motion, attaching a placeholder sheet for Exhibit 1 to the motion, and attaching 2 proposed orders referenced in the motion. It is further ordered that defendant shall file any opposition to the government's substantive motion by September 25th, and the government shall file any reply by September 30th. Accordingly, defendant's motion for briefing schedule is granted in part and denied in part. In addition, the clerk of court is directed to unseal the motion. So with that, I will go ahead and put comments on before I start digging in then into the government's motion here. So hold on one moment. Thank you, everyone. Thank you for joining me. Let me get these comments turned on so I can talk with everyone. Okay, hello, everybody. Hello. Boy, we got some last minute orders out of the court tonight. Hello. Yes, all the bots, out you go. Hello, happy Friday. Yes, hi, it's good to see you all. Yes, of course, this was such a huge moment. I thought, well, I best come on and share it. Now, this was the order that granted the government the ability to file their motion. So that's what this order means. It means the government could file the motion with some redactions in it. And the motion is this motion right here. Hot off the printer. It's still hot. Hot. Yes. Oh, hello. Yes. Welcome, everybody. Welcome. I'm so glad to see you all. Yes, here we go. We are going to get into it. Just before I get started, though, let me confirm that I'm in frame, okay? So, yes, we are up and going. This, I thought, deserved a special moment, so I thought I would go for it. So, yes, am I in frame okay, everybody? Can you see everything okay? Hello, Lisa. Hello, good to see you. I love to see it. Thanks for spending your night. Yes. Okay, excellent. Thank you so much. I really appreciate the feedback. It's hard for me to be able to tell. I've got a couple different angles, but I'm just never quite sure if I'm in frame or not. So I appreciate the help with that. This is actually a very interesting motion that was filed by the government. Now, they had to get special permission, which was the order I just went through, in order to be able to redact certain pieces of it. So, the key to this whole motion is that we've got this motion to ensure that extrajudicial statements are not prejudicing the proceedings. We don't want anything to come back and bite us later on as prosecutors when we're putting our case together. So this motion is in order to keep everything nice and clean so that on appeal, if there is a question on whether or not something was prejudicial, they can refer back to this motion once the order is granted. Now, the exhibit, as you probably just heard in the order I just went through, the exhibit is blank. It is literally just a blank page. That's because the information is protected, so it is under seal. But the rest of the information in this motion is going to be pretty interesting to go through. So I haven't gone through and highlighted anything, so we'll kind of be going through this together, but I figured it was time. Yes, so this is the government's motion. And it's, again, this is something that was just allowed to come out. It was just filed in the DC case. So let me just get, yes, prima facie just means you've got a case in fact. So thank you. Thank you so much. A prima facie case is just the standard that we use, that you've got a basis for your case. That's a phrase we would use in a motion for summary judgment explaining if the prosecutor did not have a case. You would say they are not presenting enough evidence to come up with a prima facie case, and therefore it must be dismissed under motion for summary judgment. Yes, oh, well, you know, some would say OCD, some would say, organization, whichever. Yes, I do. I need to do a highlighting reel. I do. Absolutely true. Court orders as instructive as that one, or is it due to the popular interest in the case? No, I think they're because of the nature of this case, the DC case. We haven't seen charges like this before. So like this that came out of a situation like January 6th. So this is all new. This is all first impression. So it's very helpful. Yes, why are legal terms in Latin? It's just where they came from. That was their original source, much like a lot of our medical field. Unfortunately, we're kind of working on it. I wish I could be that coordinated. Oh, VC! Yes, well, it's a gift and a curse. It's both of those. All right, let's dive right in, everybody. Here we go. Government's opposed motion. So we are trying to make sure we don't have a prejudicial situation. Since the grand jury returned an indictment in this case, again, this is the DC case, and let me take a moment here for anyone who is looking for the citation where you can find it. This is the case right here in the case number. So we've got 4 counts, violations of the United States Code, conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding, and conspiracy against rights. These are the 4 counts. We have 1 defendant in the DC case. So we now are at the most recent motion here that was just filed just like two hours ago, maybe. Here we go. The defendant has repeatedly and widely disseminated public statements attacking the citizens of the District of Columbia, the court, prosecutors, and prospective witnesses. Through his statements, the defendant threatens to undermine the integrity of these proceedings and prejudice the jury pool in contravention of the undeviating rule that in our justice system, a jury's verdict is to be induced only by evidence and argument in open court and not by any outside influence. In accordance with the court's duty to protect its processes from prejudicial outside interference, the government requests that the court take the following immediate measures to ensure the due administration of justice in a fair and impartial jury. So here's what the government's requesting. Okay, so again, let's keep in mind this is the government's motion, here. Let's keep that in mind. First, they're asking to enter a narrowly tailored order pursuant to Local Criminal Rule 57.7c that restricts certain prejudicial extrajudicial statements, and to enter an order through which the court can ensure that if either party conducts a jury study, I was wondering when that was coming up, the jury study, I was wondering, involving contact with the citizens of this district, the jury study is conducted in a way that will not prejudice the venue. Oh, that's huge. That's a really big moment. Keep in mind, they had been kind of going out and interviewing various people within the community, which if anyone has ever done a criminal trial, we all were like, well, he's doing what now? And so the government is coming in and saying, whoa, we need to not be doing that. Oh, just one moment. I need to grab another color. Just a minute. I can't go forward if I don't have the right colors. Lisa, yes, let's talk about that. So I don't have the exact details, but from what had been reported, there were people on Trump's defense team who had been going out into the community and just talking to people who could be potential jurors and interviewing them. And a jury study, it's a great question because it's something that they're creating. When we have a voir dire situation, right, we've got a group of people in the community. It's a huge list. We'll just use the number 150. So 150 people are in the jury pool for whatever period of time, right? Those are everyone that could be called in for jury duty. We can go through, look through all that information, figure out what's going to work, what's not going to work. A jury study, what they're doing here is they weren't even using a list of potential jurors. They were going out into the community and figuring out, talking to various people and kind of just polling the situation in general. Like, how do you feel about this? How do you feel about that? Just asking questions, kind of just like door knocking in a political campaign, only it was with regards to a federal criminal case. It's unheard of. I have not heard of this before. It was a lot. Yeah, just random. Is it venue or veneer? Is it a typo? The veneer. I think it could be veneer. It could be a Latin term I'm unfamiliar with. But yeah, I mean, it is the area. So I suppose it could be veneer. The face of the trial itself is probably what it's meaning. Right, exactly. So to go through and do this kind of a quote jury study, I mean, again, all of us, I think, who have been criminal defense as well as prosecutors were like, what is he doing? How's that possible? Is it illegal? Well, I think the government's coming in and saying if it's not illegal, because who does this, we don't know. But if it's not illegal, at minimum, it's prejudicing. It's putting prejudice into place for a potential jury pool. Venere. Okay, that sounds good. Thank you. Yes, exactly. So we're kind of prejudicing the whole pool of people. You can't just go door knocking and ask. Get the Black's Law Dictionary out. Yeah, it's just not at my fingertips at the moment. This was kind of a rush to get online tonight, so I will rely on my chat here to help me with some of the terms, if we have it in there. Okay, means to come. Okay. I gotta be careful. Writ issued by judge. Okay. An entire panel from which the jury. Okay, excellent. A demand from the court to a sheriff to get a jury together. Really? Okay. So again, we're talking about this group of potential people, but again, they haven't even been pooled. We don't even have that first initial pool of a jury to even go through. So this is just, again, random door knocking in DC, and the government's saying, wow, I think we're prejudicing this community. And how are we going to find fair and impartial jurors if I say, hey, did someone come knock on your door? And they say yes. From which the jury can be drawn. Okay, excellent. Thank you. Seems a bit schemy. Well, yeah. And I think the government's none too pleased about it, for sure. In Fulton County, I don't know. I really don't know. This is the only case that I've heard of them going out before the pool was even announced. So this is like way ahead of schedule. I think they're trying to force a change of venue. Well, this is really entire panel. Right. Thank you, everybody. I appreciate that. Yeah, he's like, goodness gracious, you betcha. He's like, what is happening? All right, let's dive on back in. This is a lot. And I think we're going to see some interesting little tricks like this that they're pulling where, we wouldn't even think to do something like this because our minds don't think that way typically. So the government's coming in and saying, oh, we need to figure this out. All right. The government obtained the defendant's position from counsel for the defendant, and he opposes this motion. Now, let's look at the background. Let's see if we can get some details here. As set forth in the indictment, after election, I'm going to not use this word, okay? We're going to call this Ellie Day, all right? Ellie Day is what we're going to say from now on, just to be careful. So follow along, everybody. After Ellie Day, the defendant launched a campaign in which he publicly and widely broadcast knowingly bad things, that there had been an outcome determinative badness in this presidential Ellie. And he had actually won in service of his criminal conspiracy through bad statements. The defendant sought to erode public faith in the administration of the Ellie and intimidate individuals who refuted his lies. The defendant is now attempting to do the same thing in this criminal case, to undermine the confidence in the criminal justice system and prejudice the jury pool through disparaging and inflammatory attacks on the citizens of this district. Wow, this is awful. The court, prosecutors, and prospective witnesses. The defendant's conduct presents a substantial likelihood of material prejudice to these proceedings, and the court can and should take steps to restrict such harmful extrajudicial statements. Wow, that's huge. We're not supposed to do that. Yeah, so... Yeah, it is a lot. Just keeping my eyes over there. Yeah, we just got to make sure that the F word and the Ellie word don't get put together. So let's keep an eye on that in the chat if you don't mind. Thank you. We just have to be careful. Lesson learned. All right, the defendant has a history of inflammatory and misleading statements that he knew or should have known would cause others to harass and harm perceived critics or adversaries. Jaybird, because I don't want to get dinged by the bots or anybody else. I got dinged last time. Those two words together are difficult. Yes, flagrant. Thank you. Perfect. Yes, exactly. The defendant who has an established practice of issuing inflammatory public statements targeted at individuals or institutions that present an obstacle or challenge to him. In the period between the Ellie on this date and the congressional certification proceeding on this date, the defendant trained his focus on the Ellie system, including Ellie officials and other individuals carrying out civic duties to implement fair Ellies in various states. As a result, the defendant engendered widespread mistrust in the administration of the Ellie, and the individuals whom he targeted were subject to threats and harassment. All right, now we're going to get into the first parts that have been redacted, which is what the judge's court order was about. Yes, we do need a synonym for the F word. We do. I could probably just use the F word, actually. That would probably be okay. Examples of this pattern from the indictment of the government's investigation include the following. First, this person, whom the defendant specifically targeted on the social media platform, The Bird, because had publicly stated that there was no evidence of Ellie Fiddle. Ellie Fiddle. The fun Ellie. Oh my goodness. Frank. Okay, I like fiddle. We'll go with fiddle. The bird is the word. All right, Ellie Fiddle. We look to the indictment here. After the defendant's tweet observed an increase in the volume of severity of threats against him and his family. So we have this committee that met, and that information came out. After the president tweeted at me by name, calling me out the way he did, the threats became much more specific, much more graphic, and included not just me by name, but included members of my family by name, their ages, our addresses, pictures of our home, just every bit of detail that you could imagine. That was what changed with that tweet. Whoa, that's awful. That is awful. During the Ellie, whose home, this person, again, were redacted. Person B, during the Ellie, whose home address was listed on the internet and whose family was threatened with violence after the defendant and surrogates publicly derogated Mr. B for certifying the Ellie, Exhibit 1. This is what has been just listed as a blank page for the public record. Now, person C, during the Ellie, who received threatening communication after C certified the Ellie, and the defendant issued public posts about them. Again, Exhibit 1, which has been sealed to the public. And person D, who required additional police protection after the defendant targeted person D on Twitter for this person rejecting one of the defendant's Ellie challenges. Yes, thank you. Thank you. I appreciate that. Thank you so much, Daisy. I really do appreciate that. Yes, we are tiptoeing here. We are doing well, but we are tiptoeing. The defendant knows that when he publicly attacks individuals and institutions, he inspires others to perpetrate threats and harassment against his targets. On December 1st, as the defendant was fueling an intense national atmosphere of mistrust and anger regarding the Ellie, a Georgia Ellie official held a widely televised press conference in which he pleaded with the defendant to stop, stating that if he did not, someone's going to get hurt. Someone's going to get this, and someone's also going to get this, which is not good. The defendant did not stop. Instead, he continued, even to the present, to attack individuals whom he knows already suffered threats and harassment as a result of his words. For instance, on November 17th, the defendant fired Mr. G, his appointed director of the Department of Homeland Security's Cybersecurity and Infrastructure Security Agency, also known as CISA, made statements assuring the public of the integrity of the Ellie. Later that month, after Mr. G appeared on the news program and again stated publicly that the presidential Ellie had been secure, the defendant attacked him on the Twitter, on the Bird. And on November 30th, an agent of the defendant publicly stated that that Mr. G should be, this should happen to him, which is not very nice. Taken out at dawn, and then this happened to him as well. Yikes. Whoa. This statement was so dangerous that the above described Georgia Ellie official mentioned it in his press conference when warning the defendant and others that such rhetoric would lead to violence. Mr. G and his family received these kinds of threats and had to evacuate their home. And through a December 8th lawsuit, put the defendant on explicit notice of the threats and harassment the defendant had caused. The defendant continued to publicly attack Mr. G anyway. So let's bump down and see what we're citing here. We've got a news story, NBC, CBC, NBC. Down here we have a case number in case anyone is interested in pulling up an actual case. This was out of the Maryland Circuit Court. And then we also have a court in this district recently entered a default judgment against one of the defendant's co-conspirators in a lawsuit filed against him by Mr. G for his defamatory false claims. So it looks like Mr. G did win a defamation suit. Wow. I didn't know. I had no idea it was that bad. Yeah, badness. All right. In 2020, the defendant and co-conspirators spread fiddle accusations of misconduct against Mr. H, a Georgia Ellie worker, and probably the Ellie worker's daughter. As a result, the Ellie worker and her daughter were inundated by threats, subsequently described the pernicious threats and intimidation she endured as a result of these false allegations in an interview with the House Select Committee, which publicly released a transcript of the interview on December 29th. Yikes, that's a lot. So he's citing evidence here of the dangers of this outside judicial discussions. Select Committee Transcript 8. Do you know how it feels to have the president target you? The president is supposed to represent every American, not to target one, but he targeted me, a small business owner, a mother, a proud American citizen who stood up to help Fulton County run an Ellie in the middle of the pandemic. And lo and behold, when someone as powerful as the president eggs on a mob, the mob will come. They came for us with their cruelty, their threats, their racism, and their hats. They haven't stopped even today. Within 10 days of the public release of Mr. H's interview transcript, the defendant, despite the known threats the Ellie worker had received and the established falsity of the claims of misconduct, publicly attacked Mr. H again on Truth Social through a series of repeated fiddle claims. Yikes. Likewise, the defendant recently renewed attacks on former Georgia Lieutenant Governor Mr. I, whose harassment the defendant inspired in the aftermath of the Ellie. In December, after Georgia's governor and lieutenant governor rejected the defendant's calls to appoint the defendant's illegitimate Elliors in Georgia, the defendant issued a post labeling Mr. I a rhino. Ooh, I'm not even going to say that phrase. This phrase, who was this or this, and urged we need every great Georgian to call him out. Wow, I didn't realize where that phrase came from. That's pretty bad. Thereafter, Mr. I reported he received threats. Nonetheless, last month, on August of 2023, when it was publicly reported that Mr. I had been called to testify before a state grand jury in Fulton County, Georgia, the defendant posted on Truth Social that, quote, he shouldn't testify. Ooh, is that a threat? Yikes. All right, so we've got some more instances here. The defendant continues these attacks on individuals precisely because he knows that in doing so, he's able to roil the public, and marshal and prompt his supporters. As he acknowledged in a televised town hall on May 10th, his supporters listened to him, quote, like no one else. Yikes. Ooh, that's off-putting, isn't it? That's awful. Public elected servant, just doing his job. B. Since the indictment, the defendant has deployed misleading and inflammatory statements about this case to undermine confidence in the justice system and prejudice the jury pool. Now, this is what I want to know, because we've got some serious questions going on here. Oh, thank you. Thank you for that. The defendant made clear his intent to issue public attacks related to this case when, the day after his arraignment, he posted this kind of message. I'm going to pull back on this word, the T word, and the A word. All right. So T and A, I'm just going to use the letters so that we also don't get into trouble there. I'm just trying to be careful. If you go after me, I'm coming after you. So that was what was cited before in the original motion. And he has made good on his T. Since the indictment in this case, the defendant has spread disparaging and inflammatory public posts on Truth Social on a nearly daily basis regarding the citizens of the District of Columbia, the court, prosecutors, and prospective witnesses. Like his previous public disinformation campaign regarding the 2020 Prezi Eli, the defendant's recent extrajudicial statements are intended to undermine public confidence in an institution, the judicial system, and to undermine confidence in and intimidate individuals, the court, the jury pool, witnesses, and prosecutors. Below are select examples of the defendant's disparaging and inflammatory Truth Social posts. All right, so let's get into the posts. Finally, we've got someone coming in and saying he's finally had enough, is what this motion is about. We've all been watching it. We just weren't sure when enough was going to be enough. So the defendant has posted repeatedly inflammatory A's on the judicial system, the court, and the citizens of the District of Columbia, who compromised the jury pool in this case. The defendant has made baseless claims, cited or inserted below, that the justice system is rigged against him, and that the court is a fiddle dressed up as a judge in Washington, D.C., who is a radical Obama hack, or is a biased Trump-aching judge, and that he cannot get a fair trial from the residents of this filthy and crime-ridden district that is over 95% anti-Trump. Whoa, I didn't know you had said that. Oh, that's awful. All right, here we go. We'll get into this. The Obama-appointed judge is the free speech indictment of me by my political opponent, crooked Joe Biden's Department of Injustice. Shared professional ties to the law firm that worked for energy company Burisma, based in Ukraine, of which Hunter Biden and his associate were proud members of the board and were paid millions of dollars, even though Hunter knew almost nothing about energy. You know, I'm going to pause right here, all right? I defend no one, but I will say somebody here didn't know much about being president of the United States, all right? I said it. I don't take it back. I said it. I'm not taking it back. This isn't a particularly insightful argument, okay? How much was the law firm paid? So horrible. This is classic conflict of interest, gateway pundit. Okay, so he still doesn't. I said it, all right? He's got no background. Neither does this guy. I'm not defending this guy. I'm just saying that's not a particularly persuasive argument. All right. Number 2, there's no way I can get a fair trial with the judge assigned to the ridiculous freedom of speech fair elections case. Wow, I guess we've renamed the case from US v. Trump to this. Everybody knows this, and so does she. We will be immediately asking for recusal of the judge on very powerful grounds. Ooh, powerful grounds. We love those kinds of grounds. And likewise for venue change out of D.C. Great. And that was, I don't know, August 6th, maybe? This was August 8th, so August 0 something. All the way back then. That was a long time ago. Long ago. I said what I said. I stand by it. All right. So here we go. Here's another example. No way I can get a fair trial or even close to a fair trial in Washington, D.C. I'm going to start just saying the word F again, okay? I'm worried I'm saying that word too many times, too. He does love his caps. I feel like my hair's getting blown back with the rage. All right, there are many reasons for this, but just one is that I'm calling for federal takeover of this filthy and crime-ridden embarrassment to our nation. Oh, that's mean. That's so mean. Where these kinds of people have just shattered the all-time record. Other violent crimes have never been worse, and tourists have fled. The federal takeover is very unpopular with potential area jurors, but necessary for safety, greatness, and for all the world to see. That doesn't even make sense. All the world to see people coming into Washington, D.C., this little tiny place. It's not a state. What are you talking about? Sorry. The sass is out. I put the sass away. I got to put the sass away. Putting it away. Packing it up. Here we go. This is so frustrating to me. I know. It's frustrating. It's frustrating how someone can come and say this. Had this been anybody else, they would have already been put into jail. They would have been put into jail. Okay? Anybody else? I'm just saying. Grandpa's calf's lock looks stuck. I think it is. Grandpa. Posts attacking, undermining, and attempting to intimidate prosecutors. Here we go. Similarly, the defendant has posted fake and disparaging claims regarding the Department of Justice and prosecutors in the special counsel's office in an attempt to undermine confidence in the justice system and prejudice the jury pool against the government in advance of trial. In a video posted to Truth Social, the defendant called the special counsel's office a team of thugs. Who uses the word thugs? I think only thugs use the word thugs. Again, I said what I said. Here we go. We have a Department of Injustice rigging the Ellie for crooked Joe Biden. Unless it is quickly stopped, all future Ellies will follow the same path. That's very unpleasant. It's unpleasant. It wasn't a team of goons. It wasn't a team of goons. Fair enough. Here we go. Deranged Jack Smith is going before his number one draft pick, the judge of his dreams. What? Who must be recused, in all caps again. What? Do you even know what recused means, sir? I'm not sure you do. In an attempt to take away my First Amendment rights. This despite the fact that he, the DOJ, and his many thug prosecutors are illegally... No, it's okay. It's okay. I may have lagged. I'm not getting bumped yet. Everything and anything to the fake news media. Ugh. All right, we made it through. We made it through the post. Now we'll bump down. I know. Draft picks for the DOJ, right? I mean, are they fantasy draft picks? Because those are just as important as real draft picks, okay? That's what I've been told. Recently, the defendant has spread knowingly FAs of misconduct against a prosecutor in the special counsel's office working on the case, in which the defendant has indicated that the Southern District of Florida in June of 2023. Okay, and connected those FAs to this case in the District of Columbia by calling the court a, quote, biased, Trump-hating judge. That's rude. Rude again. As shown below. Why can't he say what he thinks? Right. So you can say whatever you think about a judge like that. You certainly can, but a normal person would go to jail for that. In his posts on this topic, the defendant repeatedly makes the knowingly F claims that special counsel's office prosecutors went to the White House in advance of the defendant's June 2023 indictment for improper reasons. Here we go. Deranged. Again, we're deranged. We're deranged up here, and we're deranged again. We've got a lot of derangement going on. Jack Smith and his team of thugs who were caught going to the White House just prior to the indicting the 45th president. You can say whatever you want, but free speech doesn't mean freedom from consequences. True story, Jim. True story. That's right. You got it. 45th president of the United States, an absolute no-no. I'm sorry, what's an absolute no-no? Okay, caught going to the White House just prior to indicting the 45th president of the United States. An absolute no-no. I'm not sure which one. The indictment or going to the White House. Have been working on this, and I'm not going to say this because this is horribly offensive, for almost 3 years, but decided to bring it smack in the middle of crooked Joe Biden's political opponent's campaign against him. Ellie interference today, a biased Trump-hating judge gave me only a 2-month extension. 2 months is a really long extension, actually. Just what our corrupt government wanted. Super Tuesday, I will appeal. It's surprising. My patience, for some reason, has just been running a bit thin. It's running a bit thin for this. I think at some point we get to a point where, your patience runs a bit thin. So hold on just one moment, please. One moment. I'll be right back. Okay, we're going to make it through, everybody. We're going to make it through this. Hold on. We're going to make it through. I believe in us. We're going to do it. Okay. Hold on. One moment. All right, here we go. Here we go. It has just been reported that the aides to Trump prosecutor, deranged Jack Smith, met with high officials in the White House just prior to these political sleazebags indicting me over nothing. If this is so, which it is, that means that Biden and his thugs knew and approved of this country dividing form of Ellie interference, despite their insisting that they knew nothing. It's all a big lie. Just like Russia. What? Russia? Okay, just like Russia. By the way, there were multiple indictments. People went to prison, just saying. And not knowing about son's business dealings. Dismiss the case. He's probably thinking, that Biden should know as much about his son's business as Trump knows about his son's business. In fact, I'm sorry, I need to pause for a moment. Okay. Here we go. In fact, as the defendant well knows from the formal FBI FD 302 interview report, an agent notes that he received in discovery on June 21st. In the Southern District of Florida case on March 31st, the special counsel's office prosecutor conducted a routine investigative interview of a career military official at that official's duty station, the White House. Okay, so they went there because that's where one of the people was. Makes sense. The defendant's objective in spreading a knowing lie to the contrary, including by reposting others' True Social posts, naming the prosecutor and repeating the lie, is an attempt to prejudice the public and the veneer, and the potential jury pool in advance of trial. With that same goal, the defendant has posted misleading claims on Truth Social to insinuate misconduct by the special counsel's office in pursuing ordinary court-approved process or seeking the indictment in this case regarding a search warrant and non-disclosure order that the government received from the court consistent with the law. For instance, the defendant F claimed that the special counsel's office broke into his former Twitter account in a major hit on my civil rights and queried whether the special counsel directed the select committee to destroy and delete, in all caps, all evidence. And on August 2nd, the defendant posted a quote alleging without any basis that the indictment that a federal grand jury in this case returned had been directed by the sitting president. Joe Biden directed his attorney general to prosecute his rival. This is not an independent Justice Department. This is not an independent special counsel. This is a being directed by the commander-in-chief. Through such posts, the defendant is attempting to submit his fiddle and inflammatory claims to the public and jury pool outside of court because he knows that any such claims made before the court in the form of motions to suppress or vindictive prosecution will fail because they must be supported by evidence of which there is none. Ooh, there we go. There's a little fire. Posts bolstering or aiding the attempting to intimidate witnesses. The defendant has also posted publicly about individuals whom he has reason to believe will be witnesses in this trial. For instance, August 30th, the defendant posted a video attacking a former Attorney General of the United States, a potential witness in this case, on the very subject of his testimony. Steadily since indictment, the defendant has publicly bolstered certain prospective witnesses in this case while attacking others in an effort to influence the public and the jury's pool's impression of potential witnesses outside of the courtroom. Examples of such posts are below. Okay, are we ready? Are we ready for the examples? I'm not sure I'm ready. I'm not sure. I feel my eyes hurt. Oh my gosh. Yeah, I'm not ready. Here we go. The greatest mayor in the history of New York City was just arrested in Atlanta, Georgia, because he fought for the Ellie integrity. The Ellie was rigged and stolen. How sad for our country. MAGA! I can't. It was Stalin. Wow, it's finally happened. Little Mike Pence, a man who was about to be ousted as governor Indiana, until I came along and made him VP, has gone to the dark side. I never told a newly emboldened, not based on his 2% poll numbers, Pence, to put me above the Constitution, or that Mike was too honest. He's delusional, and now he wants to show he's a tough guy. I once read a major magazine article. Just once? Just the one time you read it? Like, it's always misspelled. Just the one time with the article on Mike. It said he was not a very good person. I was surprised, but the article was right. Sad. I can't. Oh, goodness. Okay, C. The defendant's public posts regarding this case are reasonably likely to prejudice the jury pool. That's fair. Yes, it's very sad. The defendant's relentless public posts, marshaling anger and mistrust in the justice system, the court, the prosecutors, have already influenced the public. For instance, on August 5th, an individual was arrested because she called the court's chambers and made death threats. Remember that? Does everyone remember that? It seems like forever ago, but it really wasn't. It was only 6 weeks ago. To the court that were tied to the court's role in presiding over the defendant's case. Yes, those were tough times. In addition, the special counsel has been subject to multiple threats, and two specific special counsel's office prosecutor that the defendant has targeted through recent inflammatory public posts has been made subject to intimidating communications. Given the defendant's history described above and the nature of the threats to the court and to the government, it's clear that the threats are prompted by defendant's repeated and relentless posts. To the extent that the defendant's public posts reach the general public, they also reach the jury pool for this trial. In addition, if unfettered, the way that the defendant is known to use public statements to intimidate individuals could affect potential jurors. That's such a good point. A recent incident in this district illustrates the potential issue. Last week, in a trial against a self-professed supporter of the defendant who claimed to have been at the United States Capitol on this date because of the defendant's tweets, the jury sent the court a note expressing concerns that the trial defendant might have been informed of the identities of the jurors. Note, quote, "We wanted to confirm that the defendant does not have any personal information on individual jurors since he was defending himself, includes name, address, etc. This demonstrates the need to protect potential jurors from the fear of threats and harassment that stem from the defendant's disparaging and inflammatory public statements." Let's pause for a moment. Can we think of any other famous defendants where witnesses and jurors were afraid to be a part of the process? Can we think of that? Can we think of a particular group of defendants during a particular time? Yes, I'll be over if I get booted, but I think we're doing pretty good, actually. Yeah, exactly. Al Capone. Yes, I'll bump over to YouTube if I get booted, but I'm pretty good. I think I'm in good shape. Exactly. Yeah. Yes, exactly. This is exactly the same situation, but for some reason, those connections are not being made here. But this is exactly what happened as well. I think we'll be all right. We'll see. Maybe I spoke too soon, but we'll see. All right. The court should ensure that the public statements by the defendant and his agents do not prejudice these criminal proceedings. The defendant's repeated inflammatory public statements regarding the District of Columbia, the court, prosecutors, and potential witnesses are substantially likely to materially prejudice the jury pool, create fear amongst potential jurors, and result in threats or harassment to individuals he singles out. Put simply, those involved in the criminal justice process who read and hear the defendant's disparaging and inflammatory messages from court personnel to prosecutors to witnesses to potential jurors may reasonably fear that they could be the next targets of the defendant's attacks. To protect the due administration of justice in these proceedings and ensure the impartiality of the veneer, the government proposes two narrowly tailored orders that impose modest permissible restrictions on prejudicial extrajudicial conduct by the parties and counsel. So, flipping the page, the court should issue an order pursuant to Local Criminal Rule 57.7c that prohibits certain narrowly defined statements. The court has recognized its obligation to prevent what the Supreme Court called, in Shepard v. Maxwell's carnival atmosphere, a carnival atmosphere of unchecked publicity and trial by media rather than our constitutionally established system of trial by impartial jury. To fulfill that obligation, the court may take such steps by rule and regulation that will protect their processes from prejudicial outside interferences, including by prescribing extrajudicial statements by any lawyer, party witness, or court official which divulges prejudicial matters. Consistent with those principles, the court should enter an order pursuant to the district local criminal rule imposing limited restrictions on certain extrajudicial public statements by the parties and attorneys in this case. Local Criminal Rule 57.7 permits the court, in a widely publicized or sensational criminal case, upon a motion or sua sponte, to issue a sua sponte means from the court. So speaking from the court, to issue a special order governing such matters as extrajudicial statements by parties, witnesses, and attorneys likely to interfere with the rights of the accused to a fair trial by an impartial jury. Citing this local rule, prohibiting pretrial public statements by lawyers that might prejudice the administration of justice. Courts in the district have exercised their authority under Local Criminal Rule 57.7c to issue orders restricting statements of counsel and parties in appropriate cases. And we're setting precedent here as well. And the last precedent, ordering all interested participants in the matter, including the parties, any potential witnesses and counsel for the parties and witnesses, to refrain from making statements to the media or in public settings that pose a substantial likelihood of material prejudice to this case. Other jurisdictions are in accord. And again, citing more precedent, the government seeks a narrow, well-defined restriction that it's targeted at extrajudicial statements that present a serious and substantial danger of materially prejudicing this case. The government's proposed order specifies that such statements would include A, statements regarding the identity, testimony, or credibility of prospective witnesses, and B, statements about any party, witness, attorney, court personnel, or potential jurors that are disparaging and inflammatory or intimidating. The government's order also specifies that, consistent with other clarifications, the local rule 57.7, the order is not intended to prohibit quotation or reference to public court records of the case or the defendant's proclamations of innocence. This proposal is consistent with the permissible balance approved by the Supreme Court in Gentile, or Gentile, I don't know, Gentile, I don't know, and specific enough to provide adequate notice to the parties and counsel of prohibited statements. The defendant's past conduct, including conduct that has taken place after and as direct result of the indictment in this case, amply demonstrates the need for this order. As illustrated by the examples discussed above, the defendant's statements reasonably could have a material impact on the impartiality of the jury, which is so true, of the jury pool, while simultaneously influencing witness testimony. The defendant's repeated posts that he cannot receive a fair trial from this court or from a jury of his peers in the district are substantially likely to undermine confidence in the justice system, affect the jury pool, or otherwise prejudice the due administration of justice. His misleading statements regarding the special counsel's office and its investigation are designed to do the same. And we're almost done actually. We've only got a couple pages left here. And his targeting of specific witnesses seeks to either bolster or impeach witnesses not before this court, but instead in the court of public opinion before trial begins. A supplemental order that extends some of the prohibitions that apply to the defense counsel to this defendant himself is particularly warranted. Shortly after the indictment in this case was unsealed, the defendant's lead counsel began a series of lengthy and detailed interviews in which he potentially tainted the jury pool by disseminating information and opinions about the case and a potential witness, and described in detail legal defenses that he plans to mount, including the defenses that may never be raised in court or that may be rejected by the court before ever reaching the jury, which is really important. All of those pretrial motions come into play. We have all of those kinds of issues as well. Many of these statements by lead counsel violated Local Criminal Rule 57.7, which prohibits attorneys from releasing public extrajudicial statements regarding, among other things, the identity, testimony, or credibility of prospective witnesses and the merits of the case or evidence in the case. In the time since, I just saw that. Thank you for telling me. Shift the page. Thank you. Thank you, everybody. Sometimes you got to kind of yell at me to let me know. There we go. Are we better? Are we okay? Let me double check. I'm going to wait until I hear a response. Dun, dun, dun. Okay, thank you. All right, great. Here we go. Yeah, you got to yell at me. You got to let me know. For sure. Sorry about that. All right, here we go. Many of these statements by lead counsel violated Local Criminal Rule 57.7, which prohibits attorneys from releasing public extrajudicial statements, right? Among other things, identity, testimony, credibility of prospective witnesses, and the merits of the case or evidence in the case. In the time since the court admonished the parties and counsel at the hearing regarding the motion for a protective order on August 11th, the government is unaware of lead counsel making any additional public statements of this nature. The defendant, however, has persisted. The court should therefore enter the order proposed by... Trying to make sure I'm back in frame when I flip my page. I think I'm having page flipping problems here, so just making sure. There we go. Other jurisdictions are in account. Let's just make sure. Did I flip? I flipped the wrong place. The government to ensure the defendant does not undermine the integrity of these proceedings by disseminating statements defense counsel cannot make. So let me pause there for a minute and get myself centered back again. I just want to make sure I'm in frame. I'm worried about that now. Kristen, we don't have freedom of speech here. I'm not the government. The court should issue an order that prohibits contracting the citizens of this district to conduct jury studies without first notifying and receiving authorization from the court, which is essentially, ridiculous. I've never heard of it before. The court has already taken steps to protect the veneer, so the potential jury pool, related to polling of prospective jurors related to this case at the status hearing on August 28th. After the government raised the issue of jury studies, the defendant suggested they may sooner rather than later conduct outreach to the jury pool to gather information for a potential change of venue motion. The court instructed the defendant to notify the court ex parte, which means Only one party is needed, so they didn't have to contact the government about it, before conducting any polling in the District of Columbia in connection with a potential motion to change the trial venue. Yeah, I'm not the government. So, if you get muted, you get muted. In so doing, the court noted that such polling might affect the same jury pool you're claiming is not fair, and might actually affect their ability to render a fair verdict by virtue of the kinds of questions you're asking, because questions can be phrased in all kinds of ways, which is a very good point. Because of the potential prejudice that polling may cause, the government respectfully requests the court set forth a process to review efforts by either party to engage in contacts with members of the jury veneer in this district, undertaken for the purposes of discussing case-specific facts, including any pretrial survey, poll, focus group, or similar study, hereinafter jury study. Okay. Yeah, your pocket constitution. We must have a different version. Specifically, the court should, 1, require either party to notify the court before the party or any individual or entity acting on the party's direction or under its control undertakes any jury study in this district. 2, require the completion of any such jury study no later than 30 days before the jury selection begins. And 3, require either party to submit the proposed questions and methodology. Let me make sure I'm in frame again. I've got to just double check here. Just double checking. Okay, thank you. Methodology ex parte for the court's review before undertaking any jury study. And 4, require filing under seal of the name and address of each participant contacted in any jury study at least 2 weeks before the jury selection. A proposed order is attached as Exhibit 3. Such an order is consistent with the court's inherent authority to protect the integrity and fairness of the judicial system through preventing comments that are likely to prejudice the jury veneer. Through pretrial surveys, though pretrial surveys are neither inherently suspect nor uncommon in trial litigation. Here we go. We're citing. That's a lot of cases. If questions in a pretrial survey are worded to advocate for a certain party's position or test the effectiveness of a party's message, in addition to gathering information, they can have a potentially prejudicial effect. True story. And then we're citing the Brewer case, a campaign of disinformation in... Yes, the jury veneer. Sorry, I keep saying, hopefully I'm pronouncing it correctly. So veneer are the potential jurors. So not the actual jury pool, that's not been decided yet, but the area that the jury pool will be pulled from is what they're talking about here. The potential jurors. So we don't know who the pool is. Typically, we do these kinds of questions, these kinds of things out of our entire jury pool, which would be like 150 people. We pick 16, 24, whatever. But out of those 150 people or whatever. But they're talking about thousands of people in the area that haven't even gotten notices of jury duty. So they don't even know who's actually in the pool. Okay, a campaign of disinformation in whatever form undermines the sanctity of the judicial process, and it's inimical, to the Constitution promise of fair and impartial jury trial. Fair enough. Finding that the district court did not err in relying more on comprehensive voir dire than a poll taken in private by private pollsters and paid for by one side. So again, once we have our jury pool, we ask all kinds of questions. But until then, it's a bit different. We need to make sure that we have the proper things put into place. Oh, you're welcome. You're absolutely welcome. All right, to guard against the damage that a pretrial survey could inflict on the veneer or the potential jury pool, whether intentionally or not, this court should exercise its inherent authority here. At least one district court has a standing order that requires the parties to provide advance notification when the party decides that it will or is likely to commission a pretrial mock trial, focus group, or similar study of the jury veneer. So that group of potential jury pools. And then we're citing this order here, Eastern District of Texas, a standing order. An order of this type does not prohibit use of surveys as a litigation tool, but instead regulates the practice by 1, requiring pretrial notice of intent to conduct such a study, 2, requiring disclosure of the methodology, and 3, temporarily limiting the proximity to trial, and 4, requiring in camera, which means in chambers. Oh, thank you, Greg. I appreciate that. In camera, in chambers, submission of each participant's name and address in advance of the pretrial conference. The government has attached a proposed order that contains those features. Conclusion. Consistent with its obligations to guard the integrity of these proceedings and prevent prejudice to the jury pool, while respecting the defendant's First Amendment rights, the court should enter the proposed orders imposing certain narrow restrictions on the parties' public statements regarding this case and governing any jury studies the parties may undertake. Respectfully submitted, Jack Smith, Special Counsel. So there we have it. That's a bunch of information that's just been made available to everyone. Let's see here if I can put get myself put back together again so we can do our Q&A here. Oh my goodness. All right. So what do we think? I want to wait to go through his potential orders until we actually hear from the other side, because it takes, we're just not sure if it's going to have it. Could the prosecutor ask the potential juror, whoops, I missed you. I'm sorry about that. Sorry. Yeah, I think he's got a good point. Could the prosecutor ask the potential juror if they were questioned prior to Yes, absolutely, Daisy, absolutely. And at this point you'd want to. You would make that part of your base set of questions. Please explain that last part to me like I'm a fourth grader. Oh, sure. Okay, so, all right. Yes, I mean, and you can see here's Exhibit 1. So, I mean, they're pretty careful about it. So what he's saying here is that if they want to go out and do these kinds of questioning, when they're questioning anybody who could potentially be called in. So again, these aren't people who are already called in. These are people who could be called in. If they want to ask them questions, they need to meet with the judge ahead of time to make sure the questions are appropriate and that the judge knows who's asking the questions. Oh, hydrate. All right, I will. Thanks. Just a minute. What would I do without you? Whew. Okay, so there is that. There's the explanation for that. And again, they're doing this deep dive into people who aren't even in the jury pool yet. Yes, Marble Lago. That's hilarious. Oh, yes. I'll be, I may be imbibing later. Is bad-mouthing the judge or prosecutor considered a contempt of court? Well, she had already set her order out. So, I think they're trying to walk this really fine line between, finding him in contempt or going forward with contempt versus trying to prevent it. So I think they're really trying to make a lot of accommodations for this situation. Technically, if this had been anybody else, yeah, we would have already seen contempt. We would have seen contempt weeks ago. But it's a special case, and they're really trying to kind of kid glove the situation. Isn't that swaying the jury by doing that? It is. That's what the government's saying. They're saying, hey, by going in and talking to the potential jury pool, you're already tainting it, and so we can't have that. How is that being fair and equal then? Yeah, it's yeah, it's a tough situation. This is DC. Yep, this is the DC case. We only have one defendant in DC, and I think again, they're just trying to be so careful. The goal is to get the case in front of a jury, and we're not even in front of a jury yet. So they're really kind of tiptoeing through this. Okay, what does TSC mean at the top of next to the criminal order? TC VCS? I don't know. I would assume that would be someone's name, possibly, or some other kind of designation. Oh, the judge. Yeah, the judge. Look, we've got it here on her order too. Thank you so much, VC. Boy, I would be so lost without you. I'm so thankful for my moderators. So grateful. Yes, we've got the judge. Yes, thank you, thank you. How long do you think you'd get 12 jurors in this case? Your own opinion. I think a few weeks. I think they could do it a maximum few weeks. It's definitely possible. We always find our jury, although the government's making a huge point here, and they're saying you can't just go out and canvass the entire area. And I mean, they have the money and the resources to actually do that. And so the government's saying, look, we got to kind of maintain something here in order to have some kind of impartiality involved. Yes. So this is a request, again, for very specific, very carefully worded, very fine point kind of protection order to kind of make sure that we're not tainting the jury pool, the potential. Venere. Okay, Venere. Yeah, sorry about that. Sorry. We should be okay. I'm still doing okay as far as on my end here. Would a contempt charge delay? Yes, it would. It would delay a little bit, but it'd be worth it. In most situations, a contempt, again, because she had already put out an order saying that he couldn't speak on it, right? Remember, we had that huge issue where the government had proposed an order and she kind of split it between the defendant's request and the government's request. So she split the order, and his posts to Truth Social are clear violations. I mean, that's just an easy way of looking at it, but they're just trying to really walk carefully through this. Like veneer. Yeah, veneers. Venere. I got it. Okay. I got it. Oh, the ring's getting lighter. What happens if he's found in contempt? Well, he can be fined or he can be put into jail for a period of time. He thinks and acts like... Yeah, he does. He's violating everything. He is, Frank. He kind of is. You're doing amazing public service. Oh, thank you. Thank you so much. I'm just trying to help Lollipop Break. I've got him hidden. But I mean, if it had been anybody else, he's getting a lot of special treatment. But on the other hand, I mean, they recognize how careful they have to be about things. How long till a response from the judge? She has requested defense respond back by, let me just double check on her order here. Here we go. So, what did she say? The defendant... I think it was was it the 28th? I'm flipping through her order real quick. She had put this down and said the defendant needs to respond. I believe it's the 28th. So after that doesn't look right. Hold on one moment, please. I got to find the exact right thing. I can't have it any other way. That would be ridiculous. Got to support everything you're saying. Hold on here. Where have we got it? So, defendant's motion, and then we've got court statements, and then, well, it would help if I had the right order, actually. That's not the right order. I didn't have the right order. This was Jack's response, so this is a different order, actually. Hold on, I'm sorry, I have a mess. Here we go. Sorry, wrong order. Here we go. Here's the right order. I was like, where's the date? I couldn't find it because it was the wrong order. So we have, let's see what date she put in. First Amendment, the Hubbard pieces, the Hubbard factors. All right. Reply by September 30th. I was close. I had said the 28th. So it looks like file any opposition by the 25th, and then the government shall file any reply by the 30th. So we've got two dates. Defendant's motion's the 25th, and then their reply is the 30th. Yes. Oh, I know. I'm so thankful. My moderators are amazing. The gag order's granted. Well, he's going to have to go in, and if he wants to go in and talk to the potential, to anyone who could possibly be pulled for the jury, he can. He just has to get it pre-approved by the judge is all. That's it. I mean, it's not that he can't do what he's doing. He just has to get it pre-approved. The way that he's doing it has to be affirmed by the judge first. I'm exhausted. Frank, you and me both. The 30th, yeah, it's a lot. It's a lot. But, you got to have time to get through it. And also because there's so much stuff going on with his other cases too. It seems like, especially with New York, there's all kinds of stuff going on. The worse it'll look to the jury. I agree. Yeah, 9:30 is the date that the government has to respond. So let me give you the dates again here. Defendant has to respond by the 25th. So that's 10 days, right? So two weeks, 10 days, 10 business days, right? Oh, wait, that's not right. My math is not good. They've got 10 days. So that's it. And that's not that much time. And then 5 days after that is when Jack's response is due. Can a person say they don't want to be on a jury because they're scared to be picked? A lot of people are saying that. I think it has to be taken into a factor. Absolutely, it should be. Absolutely, it should be. And it'll be up to the judge to decide whether or not that's a valid enough reason. What's the worst thing that can happen to him with these tweets? He could be potentially found in contempt and could potentially be put into jail in violation of the court order saying he's not supposed to do that. That would be the worst thing. Is it what's actually going to happen? Not at this point. I think the fact that they're tiptoeing here through this whole situation shows how they're really, kid gloving the situation, I guess is the best way to put it. Can I be on the jury? Where can I sign up? That's so funny. What realistically would happen would be he might get a slap on the hand. Well, I think it's I'm not sure. I mean, the question is, how many orders is it going to take? How many orders is it going to take before he stops? Now, some people would say he's already learning. In the most recent interview that he just did, I think there was one today actually, there were a few times where he did not say things where he could have said things. Meanwhile, he said a whole bunch of other stuff that was not appropriate. So I don't know. I really don't know how many orders it's going to take. I mean, they're trying to be very careful because the reality is, if you look at what happened on January 6th, you want to be careful. But on the other hand, we still have to uphold justice. Do you think the juries will be sequestered for their safety? I think that's a good point. I think it's a real possibility. Absolutely. He thinks he's above the law. I agree. Meet the Press Sunday. He's going to keep going on TV. Put him in jail like the courts. Yeah, I mean, there's a lot. Common person would be in jail. Greg, you're absolutely right. Why the kid gloves? I think, again, it's because there's such a huge potential for high levels of violence. And it's not just an over dramatizing. We've actually got serious situations. He's been found, and people in his circle have been found liable for defamation. They don't care. They've been held in contempt. They don't care. I mean, nothing seems to be stopping the flow here. If his supporters do react, it's going to prove their point. Yeah, I mean, it's tough. It's a tough situation because you don't want to, ultimately you want to get to trial. We need to get to trial. That's the goal. We need to get to trial. And so part of it can be, what do we need to do to get to trial? Contempt would slow us down. Even this order is going to slow things down a little bit. But this is seen as such a necessity. It needed to be done. Multiple month trial. I'm not sure it's going to be that long. Actually, we've got just one defendant. The January 6th, if you take a look and get some idea of what it's going to look like for timing, you can see how long that committee held their testimony out. So I think it would be something similar to that, plus the defendant's cross-examination. So I'm not sure it's going to take that long. Now, Georgia, that's a mess. Florida will also probably be short and sweet. New York, I don't know. New York's a mess too, but I don't think it's going to take that particularly long because we've only got one defendant. If we had multiple defendants, if his co-defendants had been charged, yeah, it'd be a mess. That's my guess. That's my guess at least. Yeah, the fear's real. I mean, the fear is absolutely real. 14th Amendment, yes, it's in the works. We've got a lot of things in the works with the 14th Amendment. Yeah, I think it's really, it's scary, isn't it? It is. It's scary. Why not request a bench trial instead? Well, I think it's because he feels like this judge wouldn't be very persuasive. Be able to be persuaded. He's already got this idea that this judge is prejudiced against him, so he's got better luck with a jury than he does with a judge here. With this particular judge, when is Letitia's New York case going to trial? So I thought the case was going in the next few weeks. I thought it was the second week in October. I thought was when her civil case was going. But that's a soft answer, as I would say in the business. I don't have a firm date at my fingertips here, but kid gloves are actually attempts at mitigating the violent potential via exhausting all options. Casey, exactly. Kid gloves is what you use when you're handling dynamite. Let me clarify that, okay? You got to be careful when you're holding something like that. Yeah, well, he's suing her again. So he's been suing her, Letitia James. He's been suing her for two years now, I think. He's been suing her over and over and over again. So there's been all kinds of orders and babies. Yes, yes, exactly. So yeah, she continues to be sued repeatedly. I would say out of all the prosecutors involved in any of the cases, she's the one that's been getting hit so hard over and over and over again. Legally, and has been for a couple of years. It's been a lot. It's a lot. Yeah, but I think the thing is though, after 2016, we had firmed everything up so much in 2020 that if there was to be an election to go through this kind of rigorous, like fine-tooth comb, the 2020 election's the one to do it. Honestly, in my opinion, if anyone was to try to do this, the 2020 election was the most well done election in the history of our country. And that's been shown. And that's because there were so many problems before, and because there was this anticipation that there could be problems afterwards. So everything was done so carefully that it's easy to show that everything was done proper because they were so careful about it. So there is that piece to it. Yeah, she's been sued. Miss James has been sued multiple times. There's going to be 4 separate juries so far. Yeah. We got Florida. We got the civil case in New York. We got the criminal case in New York. We got the criminal case in D.C. We've got the speedy trial in Georgia, and then everybody else in Georgia. Thank you for your commitment to the truth. Oh, thanks, Vanessa. I'm happy to help in any way I can, of course. I think just knowing what's going on can help you feel maybe not better about it, but at least more in control. And I think that's really important. Have the others involved be indicted after the trial? Yes, absolutely they can be. And they also can be involved in testifying during the trial. So depending on what kind of agreements have been made. So, that's a component as well. Do you think he will testify? I don't know, Jilly Bean. I think it's a really good question because he is the type of client, if he would have been my client, which he's not, oh my goodness, to be the one to say, all I need to do is get up there and tell the jury my story and they'll believe me because it's me. And so he's a classic. I mean, it seems like, he's unique. And there are some unique things only because of his prior job that makes him unique. But as far as criminal defendants goes, he's your typical criminal defendant. Like, I didn't do anything wrong. Listen to my story. You'll believe me. You'll understand everybody's out to get me. So those are the hardest clients to deal with because it's their right to testify, but they also get shredded on cross-examination. So as former prosecutor, I would always be like, fingers crossed, the defendant will testify because we'll shred him up. And that's our job. Meanwhile, as defense counsel, it was cross your fingers. Hopefully the defendant will listen to me because I'm trying to help him or her and they won't testify. If granted, what will the gag order do? The gag order would force the defendant to talk to the judge before they canvassed DC. That's what would happen. That's all that would happen. They can't just go knocking door to door and talking to people about what their thoughts are. They would have to go through the judge, set out a procedure, a protocol, and then follow that protocol. That's all it is. Can't wait to see him get on the stand. Yeah, I don't know. It could definitely be. What about posting on social media? The social media, he used that in his motion. The government used that to show the intimidation tactics that were already tainting the pool, the potential pools. So he was using that in support of saying, we can't taint it anymore. We need to have some restrictions put into place. So that's really what they're going about. But the different tweets and various things or whatever that he's posting, those are all going to fall under the contempt order. So at this point, what they're trying to do is they're trying to keep him from going out and canvassing potential jurors and doing this jury study, saying you need to talk to the court first if you're going to do that. And they're asking him, you need to quit posting this kind of stuff, setting out this kind of language that, the Justice Department is corrupt. So there is that as well. Could lead to contempt. Exactly. This would be a firmer, I guess, second layered contempt, very specific to what would be allowed and what wouldn't be allowed. Answer every question. Yeah, it's true. That's true. Although, you've got a lot of, with Jack's experience, he's got so much experience. He would be able to corral any defendant into where he wanted to go. There is no way I would want to be cross-examined by Jack Smith. There's no way. I mean, that's like who he was born to be, is to do a cross-examination of a defendant. There's no sneaking around or getting past anything past this man. There's just no way of doing it. So you go on the stand as a defendant and you get crossed by Jack, you're going to be in trouble. Hold on. Let's see. Could they get jurors from other states? No, Renee. They would have to move the trial in order to get a different jury pool. Your jury pool has to come from the same jurisdiction that your court is in. He would be the greatest witness. Yes, Greg. This will be up on my Tube of You channel. I've got 2 more posts in my queue. I've been trying to get things posted, but my lives do go a little bit longer. So this one will be up probably within 24, 48 hours, but it will be up. Absolutely. You got it. That's so funny. Yes. Yeah, it will. I will have this posted for sure. It's the same. Yeah, my YouTube is the same as my my TikTok name. Oh yeah, no, Grandma, I totally get that. You bet, Frank. You bet. I'm glad I could come on. There was just a lot going on, and it just timing worked out fine for me to be able to join. So he's still on Truth Social calling. Yeah. At least we know he's taking this seriously. Yeah, that's the thing. I think if you look, again, I'm not sure what the interview was that was on today, but there were moments when he actually paused and he said, I'm not going to talk about that. And I think that is telling. Can he blanket the DC area with ads and robocalls? Well, not anymore. Not anymore. And I think that was one of the worries, was how they were canvassing the area. Right. Always enjoy your lives. Thank you, Deborah. I appreciate that. Thank you for coming. I appreciate it for sure. I know it's a Friday night, but I thought, this just came down. I had to get on and talk to everybody about it. Legal Jason Bourne. Locke, I think that's a good description. Yeah, I would not want to cross him for sure. his PAC can do stuff like that. No, Jim, this order that he's proposing would cover that too. That they would all be covered in this. So anyone working for his side would all be covered. So there would be they'd have to be careful about all of that. Cool breeze and a hellish week. Oh, Cozy, that's so sweet of you to say. Hey, I wish I could give all of you a blow pop. I send this to you, virtual blow pop for all of you out there that's had a rough week. I know, it's been rough. I know. Yeah, I think it goes for all the supporters. I mean, that's the thing is this, he's saying, look, your rhetoric is, inciting people and you know it and you continue to do it. So we can't have it anymore. This was very informative. Thank you. Oh, you're welcome. You're welcome. I'm glad it was helpful. Yeah, she did. She went after him. But again, she's got, at this point, it's the government that needs to bring the motion. The court's not necessarily going to bring it herself. She needs a motion to respond to. Yes, you're welcome. You're welcome. Strawberry one. I love it. Summary, please. Yes. So we had the government coming in and saying, look, we need some restrictions placed on canvassing DC, looking for potential jurors, and we also need to have some acknowledgement that our true social posters or our posts are causing some harm. So we need to work on that. Worked with an attorney who worked alongside Smith, and he said Jack was great. Really? Oh, I love to hear that, Locke. That's always a great to know when people actually have those moments where you're like, okay, it's all right. To find out a particular person is doing good work. He must be. He doesn't always win, but you're welcome, Sheila. He doesn't always win, but you're not supposed to always win. I mean, that's the nature of the work. Sometimes you win, sometimes you don't win. Is he allowed to use campaign donations for his legal fund? Yeah, I think he can use whatever funds he wants. There's no restrictions on how that money is spent. And if he says that funding his legal defense helps him do his work as a candidate, then yeah, it's applicable. Yeah, thanks, Citizens United, for that one. Love that. And by that, I mean, we really don't. That was not good. That was not a good case. So yeah, exactly. Anything that can be seen as potential assistance for him in being on the campaign trail, he can dig into those funds. So it's up to his supporters if that's what they want to spend their money on. It is, Coffee Cat. That's true. It is messed up. Does the judge have to rule on this filing? Yes, she has set out a date. Defense needs to respond, and then the government can reply to defense's response, and then she will issue her order. He made millions while in office. Yeah, I don't doubt it. How's it allowed to make $7 million off of his crime? It's a weird situation. It's a weird situation. How will Jack lead the trials? He hasn't spoken in court yet. Yeah, he's keeping a lot of this pretty close to the vest, and I think that's part of his strategy. He doesn't really see a benefit in explaining it, and I like that. I think by being the exact opposite of what the defendant's doing shows kind of this almost an elegant way of going about it. So he's remaining poised, calm, what everyone needs, as opposed to kind of this sporadic, random, posts with all of these, agitative kind of verbiage involved. So he is playing literally, both where one side's gone down, down la la land, and the other side is just being very careful about it. So I think that is really telling about his behavior. What do you think the defense will respond with? The First Amendment. I think they'll just repeatedly say it's the First Amendment. He just walks away when he's done. Well, yeah, he's like, I got stuff to do. I'm just here because, somebody told me I had to show up at the press conference and do my thing, and then now I gotta go, man. He's not really into trying to pull the press to him. And you can see such a huge, stark difference between the two. Thank you so much for being here. We're glad to have you. Oh, that's so sweet. Oh, I appreciate you saying that. I'm glad you all are here too, or I'd be just talking to myself in the corner. And that would be odd, wouldn't it? The fact that he's been... Yeah, it's the money he made in yeah, I know it's a lot. It's a lot, but it's a weird situation. We're all kind of learning here in the legal field too. We're all trying to figure out, oh, thank you. That's so sweet. We're all trying to figure out, what's going on? Why is this happening? This is crazy. Like the way that they're, canvassing this potential jury pool. Like, what are you talking about? What are you doing? So, yes, so thankful for your insight. Oh, you're welcome, Auntie. I'm glad it's helpful. I'm glad it's helpful. We don't have to be afraid, everybody. We can just crack it open like a coconut and take a look at it. It's okay. It's going to be okay. It's frustrating, but it's going to come together. I know that for sure. Yes. Yeah, he did call right away, but so I do have a few more and say fiddle. Yeah, we can all say fiddle together. I do have some more things, so I will be coming back on to do a live. Not tonight. I've got some things going on tomorrow too. So, but I will try to be back on again before Monday, if not Monday, of course, at the latest. But at this point, I am doing a lot of updates because there's just so much going on. And again, now that we've got the order out of Georgia, we're looking at two cases in Georgia, two defendants in Georgia coming through. So that's going to be taking up a lot of time. So I will definitely be back. Oh, thank you, Steve. I appreciate that. Helped me so much out in the real world to be able to talk to Republicans. Oh my gosh, of course, I'm happy to help. Anything I can do to help people understand how this actually works, that's my absolute pleasure to do so. I'm just thankful that people are interested and want to know. Yes, of course, the hurricane. Oh my goodness. Oh, Suze, of course. You are so fantastic to come visit. Everybody that comes by, I'm so thankful for all of you spending a little bit of time for me. So, could he do actual jail time for this? In DC, I don't know. I don't know that jail time's really the goal. I think that accountability and the acknowledgement that his statements were fiddles. I think that that's really the key. Huge hugs. Yes. Thank you, everybody, for coming tonight. It's been wonderful. So just as a quick wind up here, we've got an opinion in order allowing for the government's motion regarding extrajudicial statements. So any of those things being posted and kind of canvassing the area for the jurors, all of that information now has been put into a motion. We'll hear back from the defense in 10 days. Then 5 days after that, the government can reply, and then we'll hear. Probably would end up where Gotti. Well, could be. Yes, you are very, very welcome. It's good to see you. Soul sold separately. Always good to see you. Always good. Thanks for coming by. Yes. Oh, it's so good to see everybody. So, yes, yeah. In the Hunter Biden, I took a look at that. At this point, I have some concerns with the law that's been charged. So until I get that sorted out, I'm not going to go through that. I will go through it at some point, but I've got a few things I need to research first, but I will definitely be talking about that at some point. So, oh yes, absolutely. Thank you, everybody. You all have a wonderful night. Yeah, I've got some concerns with the law in that case, so I had to look a little bit further into it. But yes, have a great weekend. The law is shaky. I agree. I've got to look into a little bit more. But have a great night. Goodbye, everybody. Make sure you have your blow pops. Don't be shy with your blow pops, everybody. Have a good night. Bye. Good night.